Yeah, those were very helpful comments. Thank you. On the point that punitive military action is no longer accepted as a matter of natural law, I think in part I was making the argument that sort of natural law as an independent, self-standing source of authority is no longer widely accepted among international legal theorists. I agree with your point that Grosch is focused on retribution. He's not really focused on deterrence, and it's a good point that in the Syria context that is perhaps more framed in terms of deterrence. I think even so, even if we sort of look at punishment from a deterrence perspective, positively, use of force for deterrence is not contemplated under the security, the UN Charter. So you face that problem too. On the question of a legitimate representative with whom we can engage, in Libya we do have this interesting example where you have these group arising in resistance, which it takes states some time to decide whether they're going to recognize it. Is it going to be recognized as the legitimate government, or is it going to be represented as being the state of Libya, or is it going to be represented as being a representative, a legitimate representative in some sense? And I think that these distinctions matter. I think one reason why I'd be very hesitant to embrace the idea that a state could unilaterally designate a sub-state entity as a legitimate representative and then consider that representative's consent to be sufficient for intervention is just the possibilities for it.
It's not sufficient.
Okay.
In terms of, ethical considerations, it might matter, but it doesn't authorize intervention.
Okay.
I wasn't suggesting that.
Yeah, no, I'm fully on board with that. So that it should be relevant in the Security Council's deliberations whether we have some kind of an interlocutor who is supporting the intervention. And I really like your point about just war theory. And interestingly, a lot of the points that Evan and I want to make about the use of force in the 20th century and into the 21st century is showing a return to just war principles. We can see some of that in the UN Charter already, but drawing on these kinds of proportionality, reasonableness is even thickening this idea of just war principles, coming back as a recognition that we need these kinds of thick principles in order to honor the dignity of those who are going to be affected by the use of force.
As I said, I'm not really an international law person, so I might ask something that is quite obvious. But I want to ask about your idea of deliberative engagement and take the Syrian example. And Obama saying that, suppose that Obama said this is the red line and so on. But the red line is the use of chemical weapons. Now, there we are with the question of trusteeship for whom? Is it for the Syrian people, first of all, or to humanity as a deterrence? Because I'm not sure that for the Syrian people, it really doesn't matter if they're killed by chemical weapons or by other weapons. Okay, so I mean, this is more for humanity. That's one issue. And the second question is, who do you deliberate with? I mean, in Syria, you would probably, in cases like that, you'll have various forces, and you will not. Some people will want you, some people will not want you, and so the fact that you say I don't deliberate with, I don't choose a side or representative, but what do you have instead? I mean, what are you going to make a poll or what? So I think it's very problematic. And then about your example of lawyer's-client relationship. I mean, I think that example is problematic because in a lawyer-client relationship, if the client tells you you don't do it, you don't do it. So the client has a veto power. And what you're saying, if the client says no, I go to the second best. So I think that the analogy is not sufficient.
Let's start with the second point. So I agree. I actually think that if the client says no in the humanitarian intervention context, the answer is no. So if a state, even if there, so it may be an example, for example, where you have an oppressed people and there may be a valid argument for intervention, but the people may not want that state to intervene. They might not want that state to be representing them, or they might prefer to struggle without foreign intervention for one reason or another. And I think under the circumstances, that has to be taken seriously. And it should give pause to the Security Council in authorizing intervention. And if it has authorized intervention, a state that has been authorized shouldn't take action if it's clearly in conflict with the views of the people. Now, the harder question is, what do we do if we have lots of different voices within the state, and which voices are the ones with whom we deliberate? This is a problem that actually is not unfamiliar to fiduciary law. There are circumstances where fiduciaries have multiple classes of beneficiaries who may have competing interests and may have different views about how the fiduciary should actually exercise their power. And fiduciary law doesn't have a great response to this. The response is you need to give due regard to the respective interests of all the beneficiaries, which means you need to engage in a good faith consultation of the different interests. You need to take them seriously. I think it also requires not just deliberation, but justification, a justification that takes into account the different views. I think in the Syria context, I think it is exceptionally difficult to find any kind of interlocutor, and that's if you still have to make a good faith effort to do so. But the fact that there may be discord doesn't necessarily mean that that's going to be disqualifying. That may be a situation where the Security Council is particularly important in playing a role as an independent entrustor and independent sort of arbitrator in deciding whether the state is acting in good faith in the way that it's executing its power of intervention.
And what about the trusteeship for whom?
Trusteeship for whom? Well, it's interesting. So I've been struggling with this, I have to admit myself. So you've put your finger on something that I've been thinking about. The Grotian theory, I think, would be if the state is exercising rights of resistance, it has to be on behalf of those who actually have the right of resistance, those whose rights are either have been violated or facing the imminent threat of violation, not necessarily other people within the state. And so I think that's one perspective. Maybe the state just intervenes on behalf of those. But I tend to think if the state is engaging in grave human rights abuse, then the fact that it has done so indicates its willingness to use those methods in a way that subjects all people within the state to the threat of abuse, which is a form of domination, and that in and of itself suggests that all the people of the state are the proper beneficiaries. And so, for that reason, a state needs to take into account all of the relevant interests. And that means not using force in a way that's going to have disproportionate casualties for another group, but safeguarding the lives of those who are directly at risk.
So I have probably three questions, or two questions and one comment. The question is, you refer to Grotius as suggesting that the law of nature, or international law now, we would say, permits intervention, and states may intervene. And you said in your talk that this theory authorizes intervention. And the question is whether it stops short of permitting, and or whether what we're looking for is not the authority to intervene, but the obligation to intervene, so the duty to intervene. And this is something that, we have Syria, we had Auschwitz, we had Kosovo, and whether there's an obligation to intervene, rather than a right to intervene. This is where trusteeship, the way I understand it, comes to the fore. And then the second question, or this may be a comment, I have with respect to the use in bello, the part where you talk about the infusion of international humanitarian law and human rights law. This is a very tricky problem, because if we assume that civilians are impermissible targets, that they should be protected as much as possible, it means that they should not be risked, regardless of the type of the conflict. So even if this is a war of self-defense, aggressive war, or were to protect others, civilians should be kept outside the zone of hostilities as much as possible. And so human rights obligations will also be relevant in other contexts, not only in humanitarian intervention. And the last comment is, I think, is not a comment to you, but just a general comment that comes after Sandy's point. I was thinking of following your comment about the 1938 Munich agreement, where Chamberlain comes back and says, well, we saved the world, right? So we sacrificed one people, but we saved the world. We were acting as trustees of humanity. So this is another way to abuse the argument. Thank you.
Well, let me start with the question, does the fiduciary concept permit or oblige states to intervene? So the responsibility to protect discourse, which has some resonance with this concept, this tradition, suggests that there's an obligation, there's a responsibility to take action. I think it's a, if we think about states as being fiduciaries for their people, and we think about the international legal system, international law, and institutions as having a secondary guarantor responsibility and having sort of a trustee-like character, then I think it actually makes sense, and it follows that the international community, the international law and institutions have an obligation to intervene. The question then is, where is that located, or how do we operationalize that idea, which I agree is maybe necessary in order to give credibility to the idea that states are fiduciaries if we need to have an independent arbitrator who has the capacity and the responsibility to intervene. The problem again is, so do individual states bear that obligation? I think that's a hard argument to make for the reasons that Grotius suggests. They are trustees for their people, they're fiduciaries for their people. I think there's some argument maybe that we could make that the Security Council is best positioned to bear that obligation, but in order to discharge that obligation, there need to be willing states. And so this is, I don't see an easy answer to that question. I think as currently because there's no designated duty bearer, it's not a perfect duty, but it needs to be. And so the question is, how do we get institutionally to the point where we can have that? I'd love to talk more with you about this, the jus in bello question, whether the trusteeship notion, because if we have obligations to foreign nationals outside our borders, does that mean anytime there's international armed conflict, for example, we also have an obligation to observe human rights standards? I'm sympathetic to the idea that there should be more protection, that we shouldn't be able to treat foreign nationals, even combatants, as objects that we can destroy at will. On the other hand, I think states, because they have a particular fiduciary relationship with their own people, when another state, when they have not undertaken any action to affirmatively enter into a more robust fiduciary relationship with other peoples, that there's a good argument to be made that their particular obligation to their people may trump that of foreign nationals. And fiduciary law, there are both, there are situations where one class of beneficiaries actually has rights of priority over others, and you can see how that concept might be applied here. But there are also traditions where you have to take all interests into account. So I'm not sure that fiduciary law answers the question, although I'm sympathetic to the argument that you make.
Can I just comment?
Yes.
First of all, about the obligation, I think you also have to distinguish between obligation to act and obligation to use force. And these are different concepts. I think it's easier to defend an obligation to act, whether it's to impose sanctions, whether it's to prosecute using universal jurisdiction, etc. But an obligation to use force, that's something else. B, about the application of international human rights, I was thinking if this actually, if one of the consequences is that the margin of proportionality in terms of incidental harm is narrower, wouldn't that disincentivize states to act, because this would actually transfer the risk to their own troops? For instance, in Kosovo, you also mentioned that the bombing was from 15,000 feet to protect the aircraft, and the results were more collateral damage. So this might also be a tricky issue. So.
Can I just add a follow-up?
Sure.
I want to push a bit the argument and make a distinction. As I understand Eyal is talking about a fiduciary duty for humanity. Am I correct? Now you're talking about a fiduciary duty to the people of a certain state. Now, I think that this brings, for example, we take again the example of the chemical weapons. I think that you can justify, it's much easier to justify intervention against chemical weapons and not just simple killing, or other killings, if you're a fiduciary for the humanity, and you don't solve it when you give a veto power. Let's say that we believe, let's take the use of atomic weapons, and the people in the country are against intervention. They like to throw atom bombs on each other. They enjoy it, but you, as a fiduciary for humanity, you decide that you intervene, but not for the people of a specific country.
Well, I think that's right. So that is, I do think that there's a role for the international community, again, to have a quasi-sovereign fiduciary for humanity role in preventing chemical weapons attacks. It may even have a role in punishing. Whether punishing states or punishing individuals, I tend to think the latter is the better argument. But that role is to be played by I think the international community, not unilaterally by a particular state. And because a particular state is not, because the representative or the democracy concerns are sufficiently high. So I think generally we need to have an independent arbiter to entrust authority to the state. But otherwise, I agree with you completely. There, I can see the argument you may even make that in some extreme situations, that kind of authorization could be a post hoc ratification of some kind. I'm really, obviously there are real concerns about abuse there as well. But I could contemplate some kind of mechanism that would be appropriate for that. I agree. I've thought about the Kosovo problem. My thought is, once a state undertakes humanitarian intervention, it's effectively on behalf of its people deciding to increase the sphere of its beneficiaries, so that it has to give due regard both to the interests of its own pilots and to the interests of those on the ground who will be affected by the bombing. And to negotiate those differences or those competing interests, and I recognize it may deter states from intervening. I don't know that it would. You think it would have made a difference in Kosovo or in Libya? I don't necessarily think so, but I may be wrong.
Well, I think you suggest not regular use in bello, but enhanced use in bello.
Yes.
This means more risk to
Yes.
troops and more risk for the sake of the citizenry of other states. I mean, in practical terms. But I also want to refer you to Jeff McMahon's argument that he says that actually in humanitarian interventions, you can justify incidental harm more, in a more lenient way because you're actually harming the beneficiary of your action. This is something else we should.
I'll have to look at it.
Okay, thank you both very, very much.